Welcome back. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law time. We're driving across the top of the state to get to court again. We are headed today to juvenile court, which is just about the least fun you can go to. If you can get into it, because it's closed session for pretty much everybody. Regardless, what I want to talk about is court in the COVID era. Missouri courts have largely reopened with a lot of restrictions. There are some courts that are closed still, and there are courthouses where they'll get a report of COVID from somebody who's a member or employee of the courthouse or an attorney that frequents it, and they'll shut it down, understandably. But right now, the Missouri Supreme Court has issued a number of rules on how courts are supposed to open and conduct business. I'm not going to get into all the details on that. You don't really need to know. The court, however, does, and the local judge has to. So, the local judge will enter an order and handle most of this. There we go. Now, every court in Missouri as of today, everybody in that court is supposed to wear a mask. Now, this poses some difficulties. Some of you who've been in court, move that mirror, there we go, will understand that when you're wearing a mask, it's very difficult to tell if a person you're questioning is telling the truth. More than 90% of all communication is nonverbal. Okay? Human beings communicate very much through our facial expressions, the way we hold our mouths, the set of our chin, how we speak. And attorneys, as well as investigators, are trained to look at that, as is the general public. The general public understands. You can look at someone and know you've got a good sense for when they're lying to you. Well, when a person is wearing a mask, it's so much harder to tell that. That really takes away a very, very important aspect of our trial system. If the person being questioned is wearing a mask, we can no longer identify whether or not that person is being truthful or untruthful. So the mask presents an issue, as does the requirements for the jury and for attendance in courtrooms. The rural courts just don't have the capacity for what is being asked. So there's going to be a lot of problems inherent with the way things go forward. And I don't have a monstrous criminal docket going to trial. If I did, I'd already be writing my motions for continuance and raising my objections to my client's ability to get a fair trial during the mask era. Juries need to be able to see the witness testify, not a caricature behind a mask. So that's just talking about the witness. When we come down and we talk about juries, we also have to talk about how we pick a jury. Okay? When you're limited to 10 people in the courtroom and you bring in a flight of 10 jurors at a time to conduct voir dire, and you know we're going to need 60 to 80 jurors, we go from a 2 to 3 hour voir dire process to all day. So a very minor jury trial is now an all-day trial. It's an all-day hearing. That becomes a problem. So where do we go from that? Well, just on time-wise, we can budget more time in. That's easily enough done. It's a pain in the butt because courts are busy already, but if it were just time, we can budget time in. The problem becomes, if I ask juror number 3 a question, that prompts discussion and back and forth. juror number 7 might comment on juror number 3's answer. But juror number 53 might comment on juror 7's response to juror number 3's answer. And that interaction is how we as attorneys can get a feel for who the jury pool is, who we might want on a jury and who we don't want. Now, the way this typically works is we go through, and as we're interviewing jurors, we will mark off the ones we don't want. We'll put a circle around the ones we want to keep. We'll put an X through the ones we don't want. Okay, it's very common. So, as we're listing off the jurors we don't want, if we miss that interaction, if we don't see the interaction between juror 3, 7, and 53, and we don't see the looks that jurors 33, 37, notice the 3-7 pattern, because I kind of do, are giving at juror 3, 7, and 53, we miss very, very important information. And that renders our ability to pick a jury damn near impossible. Because we have to try and expose bias. Within a larger pool, an innocuous question can expose bias. Within a small pool, that innocuous question may not get as much traction as needed to expose the bias. And bias may be, the juror doesn't like black people. The juror doesn't like Irish people. It could be as simple as juror doesn't like a guy with a goatee, and I'm the defense attorney with a goatee. So, knowing that, and knowing that we're going to have a much harder time getting to the core elements that we are required to get to, it becomes damn near impossible to hold a jury trial. Yet we're going to attempt to do it. So, what do we do? How do we go about handling this? Well, as I said, the defense bar is preparing motions, they're sharpening their blades, they're getting ready to go to war to fight this, because the defendants are not going to get fair trials. There is no question about that. We understand the court's concerns. We understand that the court system is largely shut down while this is going on, but the defendants will not get fair trials. And there's no way to get around that. First, we've talked about problems with witnesses. Second, we talked about problems picking jury members. But we haven't talked about the pool of potential jurors. There are a lot of people that will not come out to jury duty over COVID fears, leaving us with, the people that want to be there. Let me tell you, the people that want to be at jury duty scare the crap out of attorneys, because they want to be there for a reason. They want to make somebody pay. Now, that could mean they want to make a defendant pay because they were wrong sometime in the past, or they want to make a plaintiff pay because they were wrong sometime in the past. And that may not come out easily. Or they could just be completely bored, have nothing to do, and like being a busybody, which makes it even worse because they're going to try and do the attorney's job for them. Oh, well, he didn't ask about this. No, we didn't, because it wasn't relevant. Anyway, so who you're going to get for a jury, how you're going to qualify them in voir dire. Then you have your witnesses, how you're going to get your witnesses in, how they're going to testify. Are any witnesses going to bail? Is that going to be the day witness A comes down with a fever and can't testify? Well, if witness A is a prosecution witness and the jury's been sat, that case is over. Okay? Defendant walks. The jury's been sat. by the time that we find out that the prime witness has a fever and can't come in and testify, it's game over. Okay? That is a not guilty, because they cannot retry him. It's called double jeopardy. Jeopardy attaches once the jury is sat. Now, if it's a defense witness, then what happens? Do we go forward with the trial knowing the defense can't present his witness? Well, that wouldn't be right. Do you do a continuance knowing the defense can't present his witness, but the jury's been sat? Well, the defendant can waive jeopardy? No, I don't think so. This is where you run into a problem. Okay? So at that point, because the defense witness is unavailable, will they dismiss the case? If anybody thinks that the state and the court will require the prosecutor to dismiss a case, and that's with prejudice because the jury's been sat, against the defendant because the defendant's witness is unable to appear due to a COVID fear, drop a note in the comments. Not that, I want to hear that somebody actually thinks that will happen, because I don't. Likewise, I don't know of any defense attorney that's going to agree to a continuance after the jury's been sat because the state's witness can't be there. It won't happen. Now, so what happens with our all-day voir dires? Does the witness have to be there and sit there all day? Gosh, man, I don't know. I don't think so. But if they're not going to be there all day, they might actually come up with a fever after we've picked the jury. So, we picked the jury, sworn the jury in. Between the time you pick the jury and the time you swear the jury in, each party is going to be running around racing to find their witnesses. Okay? We will have already notified them beforehand. You need to be available so that we can talk to you and confirm that you're able to be here. Now, prosecution will do that. It's a lot easier when the witness is a cop. The defense will do that, and there are always witness problems. That isn't unique to the COVID era. There's always a witness that disappears at the last minute or spontaneously remembers that your client is the worst thing since shit on a shingle. That happens, and you just have to deal with it. Or that your client owes him $50, never paid him. You point out to the guy that if your client goes to jail, he's never going to get, or prison, he's never going to get paid. But now it's a monetary issue that has to be disclosed. Anyway, so the essence of this is we have so many problems with the way that we are likely going to be conducting trials that there is a real question as to whether or not we should be setting them. The problem is that victims are entitled to justice, defendants are entitled to a speedy trial, and we run into a situation where we can't do both. We can't hold a trial that's going to be a fair, full hearing of the issues, and we can't delay it without also impacting people's rights to justice. So the court has issued guidance they think will assist. And we haven't talked about what they're going to do to jurors while they're in trial. They're supposed to be erecting some kind of plastic boxes around each juror's seat. It's ridiculous. And there are places that can do that. There are places that can move their court to a stadium or an arena somewhere. But rural Missouri can't do that. Even if we had one of those facilities around, the counties can't afford to rent it out. Not for every child. So, tell me what you think. I mean, how do you think that we should handle court in COVID era? Should we charge forward? Am I off base? I mean, if you think I am just batshit crazy in approaching the defendant's right, saying, hey, you've got to be able to cross-examine the witness. If the witness is all masked up, you can't tell if that person's lying. If you think I'm off base in that, drop a comment, say something. I'd like to hear what you have to say. Please say like, subscribe, and I will be talking to you again later this week. I do want to touch base on a couple of larger issues. One is whether or not a person who goes out in public without a mask can be charged criminally, or if there might be civil liability for people that go to certain large events and then return to their community. Might they be able to be sued? We'll talk about that later this week. So, think about that. Some of you will have some good comments, I'm sure. Thank you, and I will be talking to you again soon.